Um, now, now we go to section A7. Section 7 talks about what right? The right to the right of the people to information on matters of public. Okay, I'm going to unmute you all because it is distracting.
Sorry, Kin.
Unmute all your microphone because it disrupts my discussion.
Gerald and Riza, turn off your microphone, please.
Okay, now. Now, section 7, I'm going to read first. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as government research data used as basis for policy development shall be afforded to citizens, subject to such limitations as may be provided by law. Okay, so what right that did it contemplate? The right to information of public concern and corollary rights of access to official records and documents. Okay. Now, we have a law on freedom of information, okay, which is actually a duplication of this section. You already have that right, okay, but perhaps lawyers or legislators wanted it to be more specific, okay, because there is a limitation to that, which is subject to the limitation as may be provided by law, okay. So you can actually access documents, okay, public documents if you think there are anomalies. After all, you are a taxpayer and you will be you are part of the money that was spent by government officer. Even if you're not yet working, the fact every time that you spend money in buying items, that forms part of your contribution to government. Okay, because a part of that money will be taken as a form of tax. Now, Section 8, the right of the people, including those employed in the public and private sectors, to form unions, okay, associations, societies, for purposes not contrary to law. Very important. Okay, shall not be abridged. The people that is contemplated here are those employed in both public or government employees and private, paid by the capitalist individual who also paid tax. Now, the right is not absolute. You can actually form unions. Okay, that includes government sector as well, not only private sector. But the difference between a government employee and a private employee is that although a public employee may form union, but they cannot go on strike. A private employee may go on strike. Okay, they can demand to the employer a profit sharing. After all, the reason why the employer gets the money or earns income is because of the employee's effort. So much so that at the end of the year, during Christmas, they demand for a profit sharing or a bonus in a form of some benefits or in a form of some benefits like 13-month pay, which is equivalent to 1 month salary, or 14-month pay if the employer is so generous, okay, which is also equivalent to another 1 month salary. Now, what do you mean by this? Of course, you understand what is union, okay? It is a right of the employees to form unions for their mutual protection. Associations as well. A group, okay, not necessarily registered in the DOLE, okay, they can form groups, but if they are registered in the Department of Labor, they are called unions, which entitled to rights, okay? Association is just a an organization not necessarily registering as a labor group, okay? Or societies or sororities you can form as well, but it should not be contrary to law. What is contemplated by a contrary to law? Any group that is considered to be an enemy of the state, or a terrorist group or a rebel group, okay? You may form union, but if the union or association promotes establishing a new government, okay, or promotes what is contrary to the constitution, that is a prohibited association. Now, what's the reason why an government employee cannot go on strike? Because their salary is legislated. They cannot demand to government that their salary will be increased because there is a law that provides for their increase. That is in the salary standardization law. In the case of Manila Teachers Association versus DepEd, the employees protested. Okay, they protested. It just so happened that the protest, although they walked out from their service, but it was done during break period. Had they do it other than that, then it is equivalent to illegal strike, which will result into a valid dismissal from the service. Section 9. Private property shall not be taken for public use without just compensation. Okay? Even if you are the owner of your land, even if it's titled, but that can still be taken by government for public use. And there must be just compensation. Okay? Now, it doesn't mean that if you have the title, you have the absolute right already. That can still be taken by the government if the public requires it. Now, in taking up the private property for public use, it requires not only ordinance, and not just a mere resolution in the barangay. Okay, it requires an ordinance. Example of a use of property. Let us say there's a lot. The government wanted to use it for a public market. There must be an ordinance, not just a mere resolution. A mere resolution is just an expression of their, it's just a mere expression, okay, or their likes. Whereas an ordinance is a law, okay. So a law is stronger than an a resolution. Now, there must be a just compensation, meaning there is a court proceedings that will ensue, okay, because the taking fall under expropriation, taking a private property for public use. The payment is always based on the fair market value, and the fair market value is determined by the Bureau of Internal Revenue, okay, through their assessor. Expropriation is the taking of private property with government for public use. Okay. If you recall, there are powers of the state, inherent powers. We have police power, as discussed, eminent domain, and taxation. The section 9 contemplates about the power of eminent domain, okay, which impairs obligations of the contract. Eminent domain is the right of the state to use private property for public use. Okay, after all, the owner of the government of the state of the land is still the Republic of the Philippines. Okay, under the Regalian principle or Jura Jura Regalia. Okay. Now, let's proceed. Section 10. Can you still hear me?
Yes, sir.
Okay.
Yes, sir.
Section 10. No law impairing the obligation of contract shall be passed. Okay. No law impairing the obligation of a contract. What do you mean by obligation of a contract? Okay. Obligation is the obligation to do. Okay. This state cannot impair if there is a contract binding between two persons. Okay. No law that will impair or no law will intervene the contracts or obligation between two parties. Okay. Let us say now, can there be a law prohibiting the collection of interest because of the pandemic, but there is now a contract entered into between the creditor and a debtor? Okay, that the debtor is obliged to pay a monthly amortization, for example, or a monthly obligation, let's say 10,000 every month, but because of pandemic, that obligation was impaired. It was cut. Okay, can there be a law impairing the obligation of a contract? Impairing means not allowing it to be passed. Okay, can there be a law? Okay, so we're going to think about it, what will happen, because the provision states that no law impairing the obligation of a contract. How about the president would say, oh, your obligation because of pandemic, you are not allowed to pay the rent? Would that fall under a law passed by Congress? Okay, so that is the thing that we have to consider, because section 10, the declaration of the president, might fall under this one. No law impairing the obligation of contract shall be passed. Impairment refers to anything that diminishes the efficacy of a contract. Let us say there is now a contract between the landowner or the landlord, the owner of the boarding house, and the renter. And the president would say, oh, because of pandemic, we will not allow you to collect. Okay, out of clemency, people they do not have money anymore, you cannot collect. Okay, so that's the thing that we should consider, because the section 10 article 3, no law should be impairing the contract. Now what are the limitations as contemplated there? Only police power. Okay, power of eminent domain that might curtail the obligation of a contract, that diminishes if it is in the size of freedom of religion or reservation clause in this constitution. Okay, so that is the thing that we will look into in further discussion. Now, section 11, free access to courts, okay, and quasi-bodies, and adequate legal assistance shall not be denied to any person by reason of poverty. So we have to distinguish what kind of case that we're going to file in court or quasi-judicial bodies. Okay, courts refers to ordinary courts like municipal trial court, regional trial court, municipal circuit trial court. Quasi-judicial bodies, any bodies, okay, that performs like a court. A board, for example, which sometimes which will dismiss an employee, the decision is considered a quasi-judicial body. So that decision is also binding. Now, if it is not presided by a regular court, that falls under quasi-judicial bodies. Okay, how about ombudsman? Is it a quasi-judicial body? If it is not a regular court, as contemplated in the hierarchy of the Supreme Court, which is a Supreme Court, lower than that, Court of Appeals, Court of Tax Appeals, Regional Trial Court, Municipal Trial Court. If it does not fall under that, that is called quasi-judicial bodies. Okay? Now, is there a discrimination in the access to those bodies, regular courts and quasi-judicial bodies? There's no discrimination. Okay, if you are a poor litigant, if you wanted to file a case against somebody and you are poor, you go to the barangay, declare yourself to be an indigent or pauper. Okay, the barangay would require to produce proof, okay, of income, that you have this, let us say 50,000 below yearly income, then you can qualify for assistance of the Public Attorney's Office or PAO. Okay, in filing a case in criminal, there's no need of hiring a lawyer because criminal cases is under the direct supervision of the city or provincial prosecutor. After all, the crime committed in criminal case is a crime against the state, and it is the duty of the state under the executive branch to prosecute. Okay, so the complaining witness is just a witness or the victim. You are not actually the real party interest. You are just a witness. So let's say in a crime of robbery, the victim is not actually the complainant, because the robbery itself is a crime against the Republic of the Philippines. So it will be prosecuted by the prosecutor. The victim is just a complaining witness. Okay, so there's no need for you to hire a lawyer in a criminal case because it is the job of the prosecutor. Now, until here, I only have 1 minute more. I'm going to end my recordings.